focus on the prevention and eradication of sexual harassment in the workplace is to provide guidelines to employers on the establishment of in-house mechanisms at the organization level to prevent and eradicate sexual harassment in the workplace.
First, they must make a complaint to the employer. The employer has a responsibility in investigating any sexual harassment complaint. Either whether it's a true or sometimes it's a false complaint, the employer must investigate.
Sexual harassment has a range, alright, it's a scope, it's a range of sexual behaviors. It can be as simple as a joke, sexual base, to as serious as rape. So when you have this continuum of what they call sexual behaviors, some sexual behaviors are very clear. Sexual assault, rape, you can actually take it under the penal code. Yeah, molestation, flashing and all that. But the other insidious one like a joke, lasting visual at somebody, showing pictures visually, all these are not as easy to be defined as a crime. Okay, so first and foremost, we would like to say that if a sexual behavior amounts to a crime such as rape and molestation, etc., then it can be easily proven. You can, not so easy, but at least you can gather evidence and prove the case. But for the other forms of sexual harassment, we would prefer that the burden of proof is on balance of probability. Yeah, because for a perpetrator, very often there is always a case background. If they have done it once, they would have done it before, okay? And they will probably do it again. So what we need to know is how probable it is that this sexual harassment taken place.
Sexual coercion happens when an individual uses his or her position of power to gain sexual favors. Sexual annoyance, on the other hand, occurs when someone acts in sexually suggestive ways at the workplace. Sexual coercion is sexual harassment resulting in a direct consequence to the victim's employment. An example of sexual harassment of this coercive kind is where a superior who has the power over salary and promotion attempts to coerce a subordinate to grant sexual favors. If the subordinate accedes to the superior's sexual solicitation, job benefits will follow. Conversely, if the subordinate refuses, job benefits are denied. Sexual annoyance, the second type of sexual harassment, is a sexually related conduct that is offensive, hostile, or intimidating to the recipient. It has no direct link to job benefits. However, the annoying conduct creates an annoying or bothersome work environment which the recipient has to tolerate in order to continue working. A sexual harassment by an employee against a co-employee falls into this category. Similarly, harassment by a company's client against an employee also falls into this category.
They also have another venue to complain through their employees, because it's the responsibility of the employer to inquire into a complaint of sexual harassment that happened in their workplace. The law compels the employer to make investigation. Failure to do so, it can be an offense.
Part 15A Division of Sexual Harassment in the amendments to the Employment Act 1955 applies to all employees with a service contract regardless of the wages of the employee. This provision stipulates that it is an employer's responsibility to investigate complaints of sexual harassment by the victim. Should the employer refuse to do so, the dissatisfied victim may refer the matter to the Director General of the Department of Labour. The Director General of the Department of Labour will direct the employer to investigate and report the results of the investigation to the Department of Labour or Jabatan Tenaga Kerja (JTK) within 30 days. In cases involving sole proprietorships, the victim can lodge a complaint at the nearest JTK and further investigation will be conducted by the JTK itself.
In the new amendment of the law, failure for the employer to investigate will become an offense. So So by doing so, amending the law, make sure the problem can be resolved at the workplace. If there's no settlement, or any employee will be satisfied with the decision made by the employer, after the investigation, they can refer the case to the Labour Department. Then the Labour Department will take over, make our own investigation to define whether the sexual harassment happened or not. So by that, we can give a justice to the victim.
If you want to say about alleged survivor, there are also alleged perpetrator. And that is why we say that for every case of sexual harassment, there should be a proper investigation. If it is found that it is a false accusation, steps will be taken even within the law. There has been steps of victimization. You can follow the law and take place. But for the other areas, you can take steps to, there are very many levels. Starting with the individual, how do you record every incident? The name of the perpetrator, relationship between them, date, time, place, forms, how was it done, and if you are, you talk about evidence. One of the best evidence is your documentation, because that itself is a circumstantial evidence. The other thing is the witnesses. Very often in our environment, we have people who have witnessed sexual harassment, but they don't speak up. It would be great if they don't join in, alright? But if they do witness something, speak up on behalf and support the survivor.